Hi, everyone. Harry here to talk about Donald Trump's appeal of his criminal conviction on 34 counts in New York. Feels a little bit like old history, but in fact, the convictions stay on the book. Remember that the judge basically gave him no time, but did so by retaining the record of the 34 felonies that the jury found. And so Trump bears this scarlet letter very reasonably with all the charges he was able to dodge of being the only felon elected to the presidency. And that's what he's now appealed to the appellate division in New York. So in New York, it goes Supreme Court, which is the trial level, don't ask, and the appellate division, and then the Court of Appeals would be the highest court. I was at this trial, you may recall, and I have a little sense of deja vu because the arguments are those that he pressed repeatedly and were unsuccessful at trial. Not to say that's what you do on an appeal. Of course, you try to get the Court of Appeals in question, the appellate division here, to have a different view from the trial court. One of the claims, it's actually his last one in this appeal, is the one he did again and again, where he tried to get the trial judge, Juan Merchan, to recuse on really very tenuous grounds about his daughter having worked for some pro-blue kind of consultant, and his $15 donation to Act Blue and the like. So he's tried that again. There's certainly under the law no rule to recuse, so they'd have to say that the $15 or the daughter's job was somehow an egregious conflict of interest that creates an appearance of impropriety. Okay, the other claims, again, it's a little bit like a walk down memory lane, but recall that in order to bump up the charges to a felony, and remember the charges here, this is basically the hush money payments to Stormy Daniels to keep her from coming forward with information about their having had an affair. This was in the wake of the Access Hollywood revelations, and the testimony at trial was the Trump campaign calculation was, one more like this, and it could be fatal. They packaged it falsely as a payment of legal fees to Michael Cohen, etc. You remember the basic contours of the charges. Okay, so in order to bump those charges under New York law to a felony, you needed another predicate crime. And the one they chose had to do with a violation of federal campaign law. That was considered, a possible grounds for appeal when they did it. He, obviously you couldn't bring that federal charge under state law. It's a federal charge. And Trump's argument is you can't even use it to bump up to a felony because it's preempted, because federal law controls basically election law. Of course, again, this is the law as I remember it was a little bit open-ended, or there was authority on both sides. And the basic question is they're not applying it or trying to bring it. They're using it as a predicate conviction. Could you, for example, use a wire fraud or a classic federal charge? That's what the appellate division is going to decide. And as I remember it from back then, the district attorney has a pretty strong argument that it needn't be a state conviction that you use to elevate the crime. In any event, they gave them three possible ones, and it's certainly it can't be said that the jury chose that one. So the appellate division is being urged by the Trump guys to say you have to assume it. And the district attorney, I think, will come in and say, no, even if there were error there, it's harmless error. The jury was presented with 3 different possibilities. Okay, the next thing he tries to do is piggyback on the immunity opinion by the Supreme Court. You'll remember the Supreme Court not only said you cannot charge a president or former president for official acts that she or he undertook, also said gratuitously, and I think flagrantly in error, that you can't even admit evidence of official presidential acts. Well, of course, the whole case concerned Trump, the candidate, and it all happened when Stormy Daniels came forward. But there was a small piece of evidence that when the Wall Street Journal came out with the story after he'd basically covered it up, they came out with the story when he was president that he, in fact, these things had happened, and much of the evidence that showed up at trial. There's a small piece of testimony from Hope Hicks, where she basically comes to Trump and says, the Wall Street Journal is running this article. And, he says, like, good thing it wasn't before the election. But he wants to say any conversation with Hope Hicks when she was communications director is a per se official act, the same way the court in the immunity case said any conversation with Department of Justice. Now, that seems just factually wrong, just a non sequitur, but we have that little bit from Hope Hicks. I think the very strong argument that the district attorney can make is, again, but quite strong here, it's harmless error. That little bit of Hicks and Wall Street Journal, even if it shouldn't have been introduced, criminal courts will not reverse convictions because the jury heard some evidence they shouldn't have, unless the defendant can show beyond a reasonable doubt that it would and did affect the verdict. Otherwise, you could just use any evidentiary error to start the music all over again, and you'd never be able to convict someone without a perfect trial. Okay. Third, it's what I said already, that the judge agreed. Here are 3 possible predicate acts. You don't have to all agree on which one they are. And there's a lot of cases of acts like that where it's well established that it's not an element of the crime per se, so the jury doesn't have to agree, and they can differ. This, 1 through 4 can believe this, and 5 through 12 can believe that. And so that there's nothing so remarkable or eyebrow raising about their doing that, but he'll try to say somehow that in this case it doesn't work, presumably because it has to do with federal election fraud. And that's that's really the main arguments. They are all retreads of the trial court. There's, another argument. They didn't show that he had the requisite high level of intent to defraud, which the New York statute requires. But so there you go. On the one hand, he's never going to do a day in time. On the other, the stakes are high because, it would, by happenstance, this case, which most people agreed was the least, I don't want to say meritorious, but the least sort of righteous, went least to the heart of his wickedness as a president and political official. And in America, he has made so much more caustic and debased. So the difference between there being a conviction, 34 convictions on the books, or nothing, I think matters for history at least. And so that's the stakes they're playing for. Next stage will be DA will file its responsive brief, and these things take a while. And there's, as I say, the Court of Appeals above, which has discretion to take or not take. And if they're arguing a error of federal law, as they are, they can try their, good old U.S. Supreme Court that's been so helpful to Trump in so many different instances. So it's going to be a long time, years, until we know, at least a couple years, whether or not these convictions will stand and the judgment of history as a felon will be on Donald Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.